Hi guys, it's Kathy. I hope you're doing well. My phone dings. Should I check it? No, because I just started my stream. Yep, so the other day I said a word. And then Fozzie went into chat and talked about the word. And I just wanted y'all to know it's a real word. It's real. It's real. So I'm going to prove it. I'm looking. I have it ready. I have it ready. Hi, Jazzy.
Is it this?
There's Houston, we have a problem. There we go.
Right. All right. Court calls case 24T1192, People versus Eric. Gifford, I'm just going to pull up your...
Before Fozzie learns a word, you want to know, you want a story? So I wore one of these before. It was red, and this one is purple. Okay. I might get the colors backwards, but I really don't think I am. I think I got them right. The red one was when I was dating this guy named Chris. He never saw it. Never. There was never like a romantic night, whatever they called for it. He never saw this and a couple other things. The purple one that I'm wearing now, that was James. Oh gosh, I really like James. He never saw it. Never saw it. Just sat there waiting. You guys all saw it. You guys are closer to me than. All right, we're going to learn a new word.
Here's really quick. So
Yes, ma'am.
are you under the influence? Is it this? Yes. Thank you.
If I don't mute all of my sound when the first intro song plays, you hear like this echo. So every day I mute it, and every day I unmute it, except obviously today.
Right. All right. Court calls case 24T1192, People versus Eric Gifford. Mr. Gifford is present here in person. Mr. Gifford, I'm just going to pull up your case really quick. So
Yes,
just
ma'am.
bear with me for a second. Okay. All right. I have before me plea paperwork where it does appear that you intend to plead guilty to driving while ability impaired as a first offense. Upon your plea of guilt to that charge, any original or remaining counts would be dismissed. Is that your understanding?
Yes, ma'am.
All right.
I'm not going to the bathroom.
All right. I see that you've signed the plea paperwork. Did you go through it before you signed it?
I did read over it, yes, ma'am.
Good. Did you go through the potential penalties on the second page and the rights that you have available to you on the front page? And And do you understand that by entering into this plea, you waive most of those rights?
Yes.
And you always have the ability to be represented by an attorney. If you want one, we would continue this case to allow you to get one, or you can proceed forward today without having an attorney with you. How would you like to proceed?
Yes, proceed.
Okay. Is anybody forcing you to do that?
No.
Okay. Is anybody forcing you to enter into a plea today?
No.
Are you under the influence of any substance that would affect your ability to make a decision?
Hey, Jesse, I don't know if you're still here, but I just said we're about to learn a word. Isn't that more important than school? It's an important word.
And finally, then how do you plead to the charge of driving while ability impaired as a first offense?
Guilty.
All right. Would you like to tell me what happened? You don't have to, but you can if you want to.
I mean, it was my second day of new job. My house just flooded a couple of days before that. And it wasn't even my car, it was my ex's car. She was out of town. She was in her car well, she was out of town, my house was flooded, so I was just, driving around, moving things around, and I went to go grab a slice of pizza. I guess I swerved. I did have a drink too, got my bartend. I had a shifty, but I wasn't.
Wait, what did he say? What did he just say? What was that word? Hold on. I don't know what that word was.
I went to go grab a slice of pizza. I guess I swerved. I did have a drink too, got my bartend. I had a shifty, but I wasn't.
Oh my God, a shifty. I love that word. It's a real word. It really is. So my question to him right now is, okay, a shifty is what you have at the end of your shift. You work a shift and y'all have a shifty together, or you just have one, whatever, or three. He was driving around, moving boxes. Then he got a slice of pizza. Then he had a shifty? How? You need to work a shift to get a shifty. So, yeah, I know I shouldn't. I'm going to. So today I was at work and it was boring. There was nobody there. So we were doing music bingo. And the way we do music bingo is we do a round of music bingo, but it's like a whole bunch of bingos in that round. We keep going, someone calls bingo. Okay, don't clear your cards. We're going to keep going. And then that takes a while. That takes like a while. And then we do regular boring bingo, like missionary bingo. And, B12. And then we do another round of music bingo. So me and Jessica were working and we got the whole way to the regular boring missionary bingo. And I'm like, Jess, I'm punching out. I'm clocking out because there was not enough people there for 2 servers to earn enough. So I'm like, I'm just going to clock out. I'm not going to do tips tonight. It's all yours. You have a good night. I did. I said, I'm going to tip myself $20. So I tipped myself $20 and then I got my shifty and I went to a table sort of near the bingo girl, which is my daughter, but not near enough that I would have to talk to her. You know what I mean? So we were having a great night with the customers that were there. It was music bingo. We were singing, we were dancing. It was great. The whole bar. Well, I started sitting at this table for the last round of bingo, which was 90s music. Oh, yeah, it was. Yes, it was. And, sitting there and I'm just singing loudly with everybody else, but I'm at my own table. And this one table who I've never seen before, they were new. They're like, no, come over here, sit with us. So I did. And I went over there and I sat with them and we had a blast. So the bingo caller is my daughter, so she can't really say no to me. So a couple times we went up and grabbed the microphone. We did. We had to. The songs were, singable. So we get up there. I made like $20, but I had fun, right? And then bingo's over, everybody leaves, and I help Jessica close. So, wipe tables, mop floors. So I grabbed the credit card slip from that table. There were 3 people there. I'm sorry, there were 4 people there, but there were 3 checks. I split the checks up 3 ways. So there was a couple, a single man, and a single man. Now remember, I had already punched out. I had already taken my $20 tips, and my night was over. And that fucker left oops, nope, don't say that. That man left a $50 tip, just that one man. And I was like, what? Why did I punch out? I should have stayed. He left a $50 tip, just him. So I put it in the computer without letting Jessica know. I didn't let her know. And then we close, and then I'm leaving, and I go to take my $20 and put it in the bank. And I open my purse, and Jessica had put $50 in my purse. She gave me that whole tip from that one guy, and she shouldn't have. She really shouldn't have, but yeah, he did. So I had a couple shifties tonight with the customers, and I got paid for it. I know. No, yeah, shifties is a important word. And Jasmine went to bed, and now she'll never know how important that word is. All right, now the rest of it. Hey, thank you, Michael. I don't know if you can see this, but thank you, Michael. All right. My nephew just liked this video on Facebook. Oh.
Crazy or anything like that. I was very coherent and
Okay.
And, it is what it is. I made a mistake.
All right.
And,
And now you're here.
I'm here. It is what it is.
All right.
No, dude, it isn't what it is. You were driving under the influence. You could have killed someone. Let's stop joking about it a little bit.
All right, then. Thank you for that. I accept your plea of guilt to the charge. I find that your plea has been entered into knowingly, voluntarily, and intelligently. What I'll do, Mr. Gifford, is the following. I'm going to place you on 12 months alcohol monitoring. That is essentially unsupervised probation. But you do still need to report to probation today. They will present you with terms and conditions of alcohol monitoring. You just need to sign and comply with those. Other conditions of alcohol monitoring are that you remain law-abiding and you not possess or consume alcohol, drugs, or recreational marijuana during that period of time. I will order that you complete an alcohol evaluation within 30 days. Follow those recommendations. I will order that you complete 24 hours of useful public service. I'll give you 6 months to do that.
Okay.
And a victim impact panel within the next 90 days. I will sentence you to 2 days in jail and suspend both days, and assess a $200 fine and suspend $100 of that fine, all on terms and conditions that you just comply with all of your sentencing requirements.
Okay.
I will impose standard court costs, no restitutions requested, none as ordered. I also will order, you do need to get fingerprinted still in this case.
Okay.
So I'll order that you get fingerprinted. I'm printing out a fingerprint order, and I'll explain.
Can I do that somewhere else?
Yep. Yes. And I'll explain to you how to do that.
Maybe somewhere in Avon or something?
Yes, I'm going to explain to you how to do that. So after you leave probation, if you want to get fingerprinted somewhere else, call the agency. It's a law enforcement. So whatever police department you want to do it at, call them first, find out if they'll do fingerprinting there pursuant to this court's order. If they do, just go back on one of those dates and times and then provide your completed paperwork to the court clerk.
Okay.
The last thing that you would do today before you leave here is head down to the court clerk's window. They'll tally up your fines and court costs. If you need time to pay, just ask to be placed on a payment plan. Other than that, do you have any questions about any of that?
All right. So you said you're waiving 2 days in jail if I comply to whatever I'm doing. Okay.
So effectively, you won't serve. You'll serve 0 days in jail, and you have a $100 fine plus court costs. And you have some requirements to do. They're outlined in this. You can ask for that at the court clerk's window. And you're effectively on unsupervised probation. So you're not being monitored, but they're...
In other words, don't mess up.
Yeah, they want you to just complete this stuff.
All right.
Okay? Yeah. And then, Ms. Reyes, I have a fingerprint order there I just printed. We can get that to him. We'll give that to you. and then you'll be all set.
Okay.
All right?
So I need to go to the
Probation first, and then the court clerk's window second.
Okay.
Okay. And then you should be good to go. Let's see. And we'll get that to you in just a second.
All right.
Is at the box on there on the bottom up, is it marked other so you can get it?
Nope. No, that says here an eagle.
Here, just hand it to me and I'm going to mark the box other so that you can get it at another jurisdiction too.
Hours of operation over there, small.
Okay. There you go.
Is Nan here?
All right. We're all set. No problem. Have a good day.
Yeah, have a good day.
All right.
It was just a mistake. Kelly, that was epic. The video was epic. Obviously, I can't play it, but it was epic. Okay. I'm in the middle of a stream, Kelly. You got me distracted. Let's go to a cage match. Oh, no. Nope, I'm good. Let's go to a cage match. Audio's bad, but you can hear these screaming and yelling. And that's all we need to hear is the yelling and the screaming. I love kids. I love kids.
All right. Lovely. Okay, so we'll just try to go through this. This is on number 102. This is a felony matter. We are on the record. This matter of Thomas Wesley Plum. He is in custody, is holding up his mattress.
Just so you know, he's over here. I don't know why they don't have him in the cages today. I just don't know why, but none of them were in the cages today. They're on the video screen.
Go through this. This is on number 102. This is a felony matter. We are on the record. This matter of Thomas Wesley Plum. He is in custody, is holding up his mattress against the window of his cell right now, so I cannot
Not
see
the
him.
mattress.
We'll go 989 for his name and his date of birth. He is charged with criminal threats as well as possession of paraphernalia. There is an enhancement for armed with a firearm. He is screaming and yelling in the background. Public Defender's Office is appointed.
Thank you, Your Honor. David Medina, Deputy
Oh, a Faraday cage. Oh, CJ, you know the best things to say to me.
Accept the appointment. I'll acknowledge receipt as a felony complaint. I'll waive formal reading and advisement of rights. Enter a plea of not guilty, deny any priors, any enhancements, reserve all motions, remove my client's state and federal constitutional rights, and make an I'll be asking for statutory dates.
Pretrial will be on April 17th in W11. Preliminary hearings on April 21st in W12. Both of those from the Westminster Justice Center. I have read the probable cause declaration as well as reviewed his multi-state criminal history. Are you asking for provisional bail?
I am, and just one other issue I noticed, Your Honor. It seems that when I was reading the case reports, the allegations that the threats of someone with a closed box cutter.
It's all right. We can't hear him anyway. But no, it can't be a northern term because what I just showed you was Colorado.
Mr. Collins on that, do you want to do an amendment today or do you want to just look at it and have them do that down the road?
He's yelling in the background. He's going to keep yelling.
Saying is that in fact he agrees with.
No, I call this one puzzle. You want to know why? Can you see her face? See the puzzle? The puzzle pieces. Puzzle pieces fit together. All right, he's still yelling, guys. Don't worry.
The defense that it's not a firearm, perhaps a knife, so he's, I believe, moving to amend to 12022 subsection B, subsection 1, is that what you said? Yes, now my clerk can hear that as well. We'll go ahead and move
No,
to amend later.
love, your clerk did not hear that. You spoke way too fast, way too low, and he was yelling. Nobody heard that. Is it? I did nothing.
On the enhancement goals. Okay, I have reviewed his multi-state criminal history. I also see his Humphrey's declaration. I'm assuming some indigency. Is there anything else, Mr. Medina, that you'd like me to consider?
He's asking the court for a bar release, Your Honor.
Okay, thank you. The court determines based on the evidence presented, the criminal history of the defendant, nature of the charge offenses, and public and or victim safety, and the defense current support cannot be reasonably assured without the setting of bail, and that by clear and convincing evidence, no non-financial, less restrictive conditions of pretrial release will achieve those goals. On this matter, the court will be inclined to set the amount of $40,000 as the bail amount. Mr. Collins, do you need to be heard? If he is able to post that bail, he is to submit the search and seizure, disclosure release terms upon contact with law enforcement. Possess no weapons and no ammunition, do not use the authorized drugs, do not possess consuming drugs, maintain contact with his attorneys, and make every single court appearance in person. 977 is not authorized unless the another judge or otherwise. Obey the laws, stay away from, have no communication with the victim, and stay away from the location of the incident. Mr. Medina, is there anything else I can do for you?
He's asking for a medical evaluation, Your Honor.
Of course, we'll set it for a med eval. Anything else, Mr. Medina?
No.
And then Mr. Collins, anything else for you? All right, thank you. Thank you, Deputy Nicholson.
I think I would be screaming and yelling too if my bond was $40,000. I have no idea what he did because she just went blah, 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 and he was screaming in the background and people were clicking and papers were moving and you can't hear anything. But we haven't seen the cage in a while. So I thought, now that I'm doing clips again instead of long trials, we should bring the cage back. And I did. All right. This guy's bond isn't 40,000, but it's still really bad for him.
I'd like to talk to Derek Brown. Morning, Mr. Brown.
Morning.
All right, we are here on two cases, 24M4461 and 24M5536. Mr. Brown, it looks like these cases, your bonds were previously set at $25 cash only in both of them. And your next court dates in both of them are going to be April 16th, 1:30 p.m. Division FAC for an arraignment. All right, thank you, sir.
All right, no PL bond?
No, your bonds were previously set at $25 cash only in both cases.
What? Can't have a PR bond? No, it's $25, dude. $25. No, I'm not getting demonetized. Put it in Discord. Put the video in Discord. Everybody will watch it there. Who is your favorite wrestler, guys, of all time? Mine, I don't even know if you guys are even going to know him. Some of you will, but Diamond Dallas Page. Self high five. Bam. Goldberg too, but Diamond Dallas Page. He was my favorite. All right. This guy should have been his own lawyer. It probably would have been the exact same outcome if he was his own lawyer. See, I don't know who that is. Is that a wrestler or was that the court video? I don't even know. I don't know who that is. The Rock. That makes sense. No, I thought you would like Stone Cold Steve Austin. I was sure that's what you would say. Stone Cold Steve Austin. Sorry. I don't even know who these people are. I said your favorite wrestler ever. You guys got to say like Hulk Hogan, The Undertaker, Sting. I know Sting. Oh no, Sting. Then finally, someone gave me one wrestler I knew. My son we're all Steelers fans here. Everybody's a Steelers fans. He likes Miami. My son, I'm just gonna say it. His favorite wrestler was Chris Jericho, and I took him many times to watch Chris Jericho, who I disliked a lot. But everybody disliked Chris Jericho because he was Jericho. But I had to go watch Jericho a lot because my son loved him. How do you know? Did you say something wrong to him and he turned you into a pretzel? Triple H. Yes. All right. Am I doing something? I'm doing this guy being his own lawyer. That's where we're at. This is okay. Listen closely. I'm not crazy. I know this town in North Dakota or South Dakota, in North Dakota, is Minnehaha. And I know this because we have Vibers that are from Minnehaha, and they say it's Minnehaha. But this man who lives there refuses to say that. Every single time he says Minnehaha. This guy was picked up in Minnehaha. Listen, maybe I'm wrong. Maybe I'm just not listening properly, but you're going to hear him say it.
You heard the rights I went through?
Yes, sir.
Any questions about the rights?
No, Your Honor.
Now, I have 2 warrants here. One in 243596 and one in 246375. One signed by Judge Hanson and one signed by Judge Song. Counsel?
Your Honor, would just be asking for new dates. Honestly, given the 2 different judges, I don't have notes on what one it should go to.
Actually, I thought it was supposed to be with Judge Johnson, but
Well, I'm the person who's least likely to know.
no, I appreciate that. But I think they were on Judge Johnson's trial calendar. Okay,
The clerk's office thinks it's Judge Song.
then we'll go with the clerk's office.
All right.
All right. South Dakota. South Dakota. It is South Dakota. Every time I play a video from here, I always don't know what it is, and you guys always tell me, and I always forget. Guess what I'm going to say next time I play a video from Minnehaha? I don't remember if this is North Dakota or South Dakota. But it was so weird because there was a title bar with links, a navigation bar right here on this website. And then there was words on the page, and they were all white. So the navigation bar was all white. The words were all white. So when I scrolled it down to get the thing perfectly, the white bar is over this, over what's on this page. And when I recorded it, the white just turned to black. It looks like I tried to erase it, but trust me, I'm too lazy for that. But I think he's about to say it now. He's about to say Minnehaha.
That's usually safe.
That's what I thought too.
That's my experience. Okay, Judge Song. And these are,
It'll be Danielle Foils for the state on both of these.
and defense?
The attorney for defense, sorry.
Yes.
Amber Whittington.
Yes, you're smarter than us. The whole world knows us
Okay.
better than we do.
Well, I'm going to fill out one scheduling order and put 2 criminal file numbers on it. Does that work?
Fair enough.
If the clerks are good with it, I'm good with it.
All right. At least we'll get them in front of the same judge.
Go to bed. Listen to a nice Australian read to you.
All right. Judge Song's dates will be May 2 for the plea offer deadline, May 23 for motions, June 18 for trial reset, and July 14th for trial week.
May or may not be here. In and out.
And he would like to address bond, Your Honor.
Proceed.
Your Honor, we are asking for a PR bond on these. Asher is currently on parole. Has met with his parole officer since he's been in custody. Looks like he's informing us that he was in custody in Oregon. He actually got out on Friday. He's currently living with his mom. He's okay with doing 24/7 UAs to maintain sobriety. We have contact information for him. Do believe that there is a competency evaluation pending as well. With regards to the actual cases related to
He doesn't need a competency eval. He just doesn't. Fozzie. Fozzie. Fozzie, come here. You're needed. Look at chat.
two pending ingestion cases where he was alleged to have overdosed, and there was family that had called for help. Don't believe I've seen any, or I did a quick look. I didn't see any new charges in Minnehaha County or South Dakota for any drugs or anything like that. Apologize, he's ready to
Fine, go away. Just, Smith, just thank me instead. You don't need to thank him.
So he's
you.
informing me that he's in contact with his PO, that they know what's going on. Thinks there's just a little miscommunication, accident with the missed deadline here. So for those reasons, he's asking for that PR bond.
So do I understand he was in prison until what, 3-4 days ago?
No. Just in jail.
I was just in jail. I got arrested for trespassing, and
In Oregon?
in Oregon, and my parole officer didn't put a hold on me or send a warrant for me at all. So that's why I missed a court date and missed a evaluation with my lawyer. So my lawyer called me Friday and told me to get a hold of her, but I did not have data on my phone, and I was already on a bus back to Sioux Falls to check in with my parole officer. I just checked in with him Monday, and I didn't know I had a warrant because there was a warrant that just put out Saturday, and I was supposed to get a hold of her. You know, she left me a voicemail box Friday, and I didn't get a hold of her that day. You know what I'm saying, because I don't have data on my phone.
I would come
on
for
my
a
bus
12
back.
pack too.
I just see my parole officer Monday, and what is today?
Wednesday.
Today's Wednesday, so yeah, I got picked up yesterday. So,
Mr. Sample?
State would ask that the warrant amount beat the bond. The state's concern here is that here he is on
No.
parole supervision. He's not being compliant,
told me to
continued
check
drug
that.
use. He's getting arrested in a different state. The state believes that he is a flight risk and that he is a danger to the community and to himself. So I'd ask that the bond remain.
What is bond currently?
$1,500 on each file, Your Honor.
Okay.
Wouldn't it be a lovely dinner date? Wouldn't it? Wouldn't it? Stupid men. Stupid. Mean.
All right. I'm gonna leave bond to $1,500 cash only on each file. And the conditions, if he makes bond, or again, your good behavior, stay in contact with your lawyer, make your court appearances, no weapons, no alcohol, no drugs without a prescription, and comply with probation and parole.
Just so I can be able to find out. Your Honor, he does want me to ask if you would consider cash as surety as opposed to cash only. So I can find out.
He would have made a good lawyer. He just would have. He's doing a good job.
Mr. Sample?
State would oppose that, Judge. State believes he is a danger and the amount of bond was proper.
Hey, what, counsel? Why don't you reserve that argument and take it up with the next judge?
Understood.
You got some great ones. Donald, you 9 months? Holy free-holies. That's awesome. Thank you. I blame Kat for anything, everything. It would be more, but I messed up. I did mess up. Okay. Last one before Fleischer is a landlord-tenant case in Georgia. Except this one. So, Georgia, it's just like Florida is two states. We got South Florida, which is, those are sort of like northerners. And then we got North Florida, and those are southerners. Okay, does that make sense so far? But we're in Georgia now. We're going to see a clip from Georgia. But this is, I think, somewhere not so North Georgia, but sort of a little above South Georgia. Because they have the accent, sort of, like you could hear it, but it's only sort of. But their words are more, they still say what, but they don't say July. So I don't know what state they're in. North Georgia, mid Georgia. I'm going with mid Georgia or South Georgia. There's no math involved. There's just an almost accent. Like they almost have an accent. No, it's Dawson County, Georgia. All right. I should press play.
Tap it, finger. Okay. Can y'all hear him? Yeah. All right. He has been sworn in. I'm going to go ahead and swear you in. If I could get each of you to raise your right hand, please. Do you solemnly swear that the testimony you're about to give in the matter now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Yeah. All right. Thank you. Okay. Mr. Betterton, I'm going to let you start. Go ahead, and I have read your filing. I've read the lease and the sales agreement, so I think I have a little bit of background, but
that is precisely what I meant to say. It's South-North Georgia. South-North Georgia, so now you know. It might be, but it's not north because what still happens. They still what you. You can hear his accent a bit, and he says y'all.
Still need you to tell me what's going on.
I have a prepared thing. It'll take about 5 minutes. Is that okay?
Okay, sure.
All right. And so it's my understanding that the defendants, Patricia and Timothy, built this home around 2000, 2001 timeframe. I believe they have lived in the home since that time. And Tim suffered a stroke a few years ago. And and Trish is his primary caregiver. At some point, they fell behind on their second mortgage, and the bank foreclosed, and I purchased the home at a foreclosure auction on the courthouse steps in November 5th of 2024, over 5 months ago. After purchasing the house, I immediately, the same day, went over to meet them, introduced myself, and let them know what had occurred. And Trish informed me at that time about their health and caregiving situation. And although it was my desire to take possession immediately,
I feel like that's a trick question. I feel like that's a trap and it's a trick question. And now we're playing trivia.
I agreed to consider letting them stay for a while and renting it to them. So we signed a lease in December 17th of 2024 for a reduced rent amount of $1,000 a month because I had sympathy for their circumstances and also did not charge them rent for the period from November 5th through December 15th. I made it very clear in the written lease as well as in the lease when we signed the lease in person that they needed to do whatever was necessary to be out by March 15th. And this deadline of March 15th gave them a total of 131 days from the time I notified them that I had purchased their house at foreclosure until they needed to be out. And I believe this is much longer than any other investor would have given them. I checked with Trish a few times during that period and to see how their packing and moving was going. She informed me that she had a large quantity of confidential papers that needed to be destroyed. And she said it was taking her a long time to burn them. And I offered to help her. I purchased an industrial paper shredder for $700 and offered to either destroy them for her while she watched or video it for her. And she agreed to leave the papers in the garage and I would do that. And on March 16th, the day after they were supposed to be out, I was prepared to go and get those papers and shred them. And she
That's what happens when you play around in the middle of a live stream. You misclick.
Start, go ahead and I have read your
introduced myself and let them know what had occurred. And Trish informed me at that time about their health and caregiving situation. And although it was my desire to take possession immediately, I agreed to consider letting them stay for a while and renting it to them. So we signed a lease in December 17th of 2024 for a reduced rent amount of $1,000 a month because I had sympathy for their circumstances and also did not charge them rent for the period from November 5th through December 15th. I made it very clear in the written lease as well as in the lease when we signed the lease in person that they needed to do whatever was necessary to be out by March 15th. And this deadline, March 15th.
Security. I saw Happy donating and I thought it was a great family friendly, cuddly, make you warm inside message.
Gave them a total of 131 days from the time I notified them that I had purchased their house at foreclosure until they needed to be out. And I believe this is much longer than any other investor would have given them. I checked with Trish a few times during that period and to see how their packing and moving was going. She informed me that she had a large quantity of confidential papers that needed to be destroyed. And she said it was taking her a long time to burn them. And I offered to help her. I purchased an industrial paper shredder for $700 and offered to either destroy them for her while she watched or video it for her. And she agreed to leave the papers in the garage and I would do that. And on March 16th, the day after they were supposed to be out, I was prepared to go and get those papers and shred them. And she texted me and informed me they wouldn't be out after all. So my point in saying all this is that I have sympathy for the difficult position that they're in. And however, I feel that I've treated them more than fair in a more than fair manner and have made every effort to help them. And I agreed to allow them to stay in the house rent free for 41 days and then for 90 more days at a reduced rental rate. and offered to help them destroy the documents when I found out they were having trouble, and then offered to let them leave behind any of the stuff they didn't want, and I would dispose of it at my expense. In addition to trying to accommodate the defendants, I have also incurred inconvenience and expense as a result of them holding over in the house. I arranged for my business partner to cover all of my work for 3 months while I was planning to renovate the house. I've also purchased new kitchen appliances, which I'm having to store now because I don't have a place to put them. And I understand that the defendants have lived in the house for 24 years, and I'm sympathetic to the health conditions and hardships they face. But I believe the court should agree that 131 days is more than enough time to pack up and move any size household. And they are now at 156 days and counting. And I request that possession be granted as soon as possible and a judgment awarded in my favor in the amount of $2,760, representing the holding over fees of $100 per day, as specified in the lease sections A14 and B14, and staying 26 days beyond the agreed upon deadline, and also legal expenses of $160 for the court filing fees.
All right, Mr. and Ms. Belcher, what would y'all like to tell me?
Okay, everything he said is pretty much correct, but I did pay the mortgage in November.
Everything he just said was correct, but I did pay the mortgage in November. It's going to be really hard to hear these two, but we only really need to hear the judge and this guy. And you heard everything he said. No, security, no, that cat I'm going to yeet. Just kidding. That's my favorite. That's Lafayette.
So I thought that's why he started the lease in December.
Okay, well, yeah, he's not asking for that, so that's that. It's good for me to know that, but that really isn't part of what we're talking about. So go ahead.
So when I didn't even know the house was going up. I knew I had a problem. I did not know it was going up.
Now she's saying when she lost the house, she never knew she lost the house. She just got an eviction notice one day.
And then now that month it was freezing cold, and it was Thanksgiving, and then the next month was Christmas, and same thing. You know, my husband.
So she got her eviction notice, but it was freezing that month, and it was Thanksgiving, and then it was Christmas, so she couldn't leave.
I'm dealing with, he's not messing with old things. And so my whole life, we've been here 24 years, my whole life, equipment, tools, everything. I had to get rid of it, and I needed money. And so I wanted to sell stuff.
She has way too much stuff in the house. She's been there for many years, and she wants to sell it so that she can make money. So she can't move all the stuff out of her house. Too much stuff.
It's cold and wet, and it's snowing, and he's disabled. It's hard enough taking care of a disabled person, let alone I have all this to do, having to be both stuff.
She has to take care of him because he's very sick, and she has to pack all by herself.
I worked so hard to try to do this.
She's working so hard.
Where I got to get people here to come in and try to buy some of this stuff to get it out of here. And so that's where we're at. And then he went into the hospital on February the 5th. So that's and then plus I was sick 3 or 4 times because it was so cold.
3 or 4 times. She was sick in the last 120 days.
3 to 4 days. So that's basically where we're at. And I've got the money to pay him. You know, I got stuck in a situation where somebody informed me that I could have a chance of reclaiming my house. And that's why that happened at that time, Terry. It just happened. And I was like, I love my house, and I wanted my house back. And
she wants her house back.
by the time I got a hold of an attorney, the eviction notice came. And so this is where we're at now. So all I'm asking is just give me a couple more.
120 days is not enough. She needs more time.
But when I have him call me an hour for something, and I have no schedule. If he needs something, it might be 10 minutes. It might be an hour. It might be 4 hours. And then found his request, and he did it.
Because of his disability, he needs attention. And she never knows when he's going to need attention. And she never knows if it's going to be like a 5-minute thing that he needs or hours long thing that he needs. And it just happens at the drop of a dime that she has to go care for him for an unspecified amount of time. So 120 days is just not enough. 120 days.
And I will pay for your fees. I did not get my money from the foreclosure till March 28th. So I had no money to get guys, to hire guys to help me move some stuff or whatever. I haven't even looked for a house. I haven't even looked for a place to live because I've been too busy trying to do everything else until I didn't have any money.
In the last 120 days, she hasn't even looked for a place to live. She doesn't have time.
And that's pretty much it.
All right. Well, here's where the court is, and this is one of those things that it's hard for everybody involved because I understand and fully sympathize. I've been in your shoes as far as the caregiver situation. I've also been in Mr. Betterton's shoes as a reluctant landlord and in a situation that involved the sale of a property, and especially if all of this landed on you without a lot of time or a lot of notice. The issues are these.
120 days.
This is going to sound harsh, and I don't mean it to, but it's where we are. The sale of the house, and if you didn't have weren't given enough time to be able to react to the situation, that is.
She clearly did not have enough time to react. 120 days.
Well, that's just awful. I mean, if you didn't have a chance to react to that, but that isn't where we are now. The sale happened. Mr. Betterton owns the property. When y'all signed a lease, a 4-month lease, actually 3-month lease, you knew this day was coming. And again, I understand your husband's health issues, and I sympathize with that because, as I say, I've been in your shoes with having to be a caregiver, and you're right. Sometimes you get a call that is going to be something you can handle in a few minutes, and sometimes it's a day, and you have no idea going in when that's going to be. The issue is that from Mr. Betterton's standpoint, the people to whom he owes money, storage for appliances and things like that, he acted based upon the lease that you had, and you entered the lease knowingly and intelligently and voluntarily, and he is certainly allowed to depend on that. And when the lease says y'all are going to be gone by the 15th of March, then he goes and makes business arrangements based on the fact that y'all are going to be gone by the 15th of March. And he's trying to work his property. The people to whom he owes money really don't care about any of this, of what's gone on. To ask him to extend puts more financial burden on him. I don't know what he's paying in storage costs. I don't know what he's having to deal with as far as his employment is concerned. His testimony is that he's got somebody covering that for him. I don't know what complications that creates, if any, financially or otherwise. But basically, you're asking to be to allow your hardships to increase his hardships.
She's not asking. She's already done it. Like, she got evicted a long time ago. Security, that's what I'm wearing right now.
And that's it's just not fair. If this were something where you had the minimum notice allowed by law, and then your husband's health issues came up, and all these things happened at or about or shortly after the time of notice, then I think it wouldn't be unreasonable to at least inquire of Mr. Betterton if he'd be willing to make some concessions. But with as he has testified to, 150 some days. I know they're expensive, but a moving company can have everything packed up and gone in 2 days. And I realize moving companies aren't cheap. But to ask to be allowed to have the time to do all of this yourself, just isn't reasonable for Mr. Betterton. Let me ask you this: give me a figure, and he can hear you, and he probably suspects what I'm about to ask him. But when you say you would ask for a little more time, give me a figure. What is it that you would be asking for?
7 more months.
And I would pay for his expenses, but his rent.
I think she asked for 2 more months. I'm not 100% sure, but I think she said, yeah, I think I need about 2 more months.
Betterton, let me throw back to you. Do you have? And I'm not trying to pressure either the Belchers or you into anything. I'm simply asking because I don't know without asking. But what would that do to you if you were to charge your expenses and them still occupy the property for another month?
A month.
So we'd be talking essentially 2 months past the term of the lease then, because we're already almost a month past now. So you're talking like 15 May. Is that what you'd be talking about, Ms. Belcher?
Yes, sir. Yes, sir.
So that would be essentially 2 months beyond the termination of the lease. Is there a figure that makes you close to whole?
So the figure of rent or a figure of time?
Everything.
Okay.
I mean,
everything altogether.
Anything that would make it palatable to you. And the reason I'm asking is, and you kind of heard me talk to some of the other parties, is
He did hear him talk to the other parties. Maybe I'll play it. I don't know. But, okay, while this judge was doing the cases with the other parties, this bailiff stands up and says, everybody leave the courtroom now. Everybody leave the courtroom now. Judge, stay there. And the court reporter was allowed to stay there. So, like, everybody just got up and he's like, leave now. Leave the courtroom right now. Nothing was happening in the courtroom. So the judge and that were just looking at him, and he got everybody out. He came and shut this door and then locked it. And then he left and locked the door. So now it's just the judge and the court reporter in the courtroom for a while. And no one was allowed to go into the courtroom. The doors were all locked. No one could get in. Right? So then finally, and Walter, then finally, I don't know how much time passed. A bunch of time passed. The bailiff comes back in, says, okay, you may resume now, Judge. No, I'm not. I'll show it. Not today. I don't have it ready today. But what had happened was there was an inmate in the back that threw a fit, and there's only 2 guards. So this guard had to go help the other guard. He needed to, but he would not leave the judge alone. He would not leave the judge unprotected. So instead of running back to help the other guard who was fighting with an inmate right at the time, he waited. He got everybody out of the courtroom. He waited. He locked all the doors. And then once the judge was in here locked, he went to the back to help the other guard. I just thought it was so cool.
On the one hand, the Belcher situation is real, but on the other hand, as I told them, you still have the things that you have, and the mortgage company, once the payments for the house, they don't care about any of this. If I get sick, my mortgage company wants their check. They don't care.
So honestly, this is going to sound crazy, but I want what's best for them. And I think what's best for them is to go live with their family, his family in West Virginia, which they had mentioned doing. Because if they stay another month, they're going to owe me more rent, which I think the reduced rent was $1,000. I think the market rent's significantly more than that. And I don't really want their money. I just want the possession of the property.
Right.
So,
and that's why it's a hard question, because to make you whole, it does just put it sounds like it's, and Mr. and Ms. Belcher, I want you to understand, have you been able to hear Mr. Betterton?
Yeah.
Because the point he's trying to make, and I don't mean to put words in your mouth, and let me know if I don't say this as to what you mean, but this is often a situation in these cases that we come to, is that you're asking for more time and willing to cover his expenses during that time, but then that puts a burden back on you that it increases your burden so much that it oftentimes puts the person with a much steeper hill to climb, and they didn't realize that. I mean, they said those things in good faith and wanted to clear things up, but then got zapped with a figure that was just couldn't be done. And what he truly needs is the property. And again, I realize you have a lot of things going on. Where are you physically right now? Where?
In the house.
Oh, okay. All right.
We are moving to West Virginia, but it's just, I have so much stuff. I mean, we had a 2-car garage. We had nothing but tools and equipment. And I need to get a U-Haul. I need to, I haven't even had a chance to look for a place to live. And then we could live in the Romans or,
She needs to get a U-Haul, and she hasn't even had a chance to find a place to live.
But anyway, that's where I'm at.
Well, my suspicions, and as I mentioned, I know moving companies aren't cheap, but I suspect and I don't know, I haven't done the math, and I was not a math major. It's not my strong suit. But I would bet that a moving company would be less of an expense, as expensive as they are. I bet it would be cheaper than what Mr. Betterton would have to ask for, with 2 months rent plus all his storage expenses plus whatever he's losing business wise. You add all of that up, and I just bet a moving company would be cheaper. And as I say, this is what they do. They show up. In 20 years on active duty in the Air Force, I moved 17 times, and moving companies swoop into your house and they have it done in a day and a half. Even if it took 2 or 3 days.
Thank you for your service.
It's what they do for a living, and they know how to do it, and they can do it even if you have other things pulling at your attention at the time. I'm not trying to. I guess maybe I am trying. I'm not trying to pressure you to do that, but I'm throwing that out as something for you to consider. That I just bet that would be cheaper than and certainly less mental anguish than you trying to be a caregiver for 2 hours, then run look for a U-Haul, then run back and be a caregiver for a while, and then run back and do some packing, and then be a caregiver for a while, and then run back and try and organize some things. And
It's fine, because you know what? I wasn't thinking clearly, and the words that I just said a minute ago were bad. Like, I was stumbling. Monday, I do have something special going on. I do. So Monday, I'm going to do my 2-hour stream like I always do. No changes. Free. But then, if you want me to stay on and keep my life going any further than that, it's up to you. You're the boss. $1 a minute. We already have 400 minutes. Hold on, I'm looking. Here's what we have so far. We have Fozzie bought the first 100 minutes after the 2 hours. Zach, 5 minutes. Fletcher, 9 minutes. Springsteen, 2 minutes. Debbie through JK, 10 minutes. Monica, 60 minutes. Nan, 50 minutes. So on Monday, I have off. So if you want me to keep it, no. You can add 1, 2, 3, 3.5 hours right now. Yeah. It's $1 a minute. He paid $9.99. If he wants 10 minutes, he would have had to pay $10. Yep. He gets 9 minutes. Not even 9.5. No. Maybe I'm worth it. Sorry. So I know. So I'm going to keep going. It's going to be a marathon as long as you guys want it to be, or I can just stop streaming and go to bed. I round down. That's right. I round down. But no OJ. I know you guys are going to ask a million times again between now and then. There is no OJ on Monday. You can't even have orange juice. I don't know, Vicky. No, Kelly, we have to be good. Kelly, nope. Don't say it, Kelly. Stop typing, Kelly. We have to stop.
then be a caregiver, and then run back and get some finances in order. And all of this, it's gonna drive you nuts. And you are trying to do the right thing. The court appreciates that. Mr. Betterton appreciates that. I tend to agree with his assessment that it is going to be easier on you the sooner you can be out of there. As much of a burden as that will be less of a burden on you than doing it the way you're trying to do it. So anyway, that's my 2 cents worth. What's your response to everything I realized I went on and on, but what's your response to that?
I've never even thought of a moving company, to be honest. I've never even thought of that. So,
well, the court's displeasure in I shouldn't say displeasure, but the court's preference in steering away from a dispossessory, and you weren't present for.
You should have made it $2.01, but you didn't. 2 more minutes added. Thank you, Fozzie.
I've heard a dispossessory case just before I called this one. With a dispossessory, if the court issues a dispossessory, you have 7 days, and the court does not have the authority to extend it or shorten it. That is set by the legislature. It also goes on your record and makes it hard for you to, I don't know that it is something on your record that other landlords, if you go to rent somewhere, are going to see that you've had a dispossessory filed against you. And that's why the court sometimes wants to explore the possibility of something that is a consent between the parties as opposed to a dispossessory. Because a dispossessory is a harsh thing, and where the court has no problems with a dispossessory is when someone is willfully trying to cheat the other party. When a tenant is just running rampant over a landlord's rights. But that's not what's going on here. Y'all have issues that you have to do, real issues that you have to deal with. Mr. Betterton is very sympathetic, and he has real issues that he has to deal with. And I just, when you've had a 3-month lease plus a chunk of a month before that, and you've had this amount of time, I don't think it's reasonable to ask Mr. Betterton for 2 more months. I don't see how that is reasonable.
Oh. The notice that I got was when Mr. Betterton came and told me he bought the house.
JK, thank you. Thank you so much. Okay, now Fletcher gets 10. Thank you.
All right, so we're talking we're talking essentially from a practical matter. Then we're talking end of April, which happens to be 3 weeks from today.
We do it on the weekend. I know. Can we do it on the weekend though? Like.
Well, you can do if I'm gonna talk to Mr. Betterton because you and I have chatted a whole lot. It's basically been me talking, but we've been chatting, and I want to hear from Mr. Betterton and give him a chance to weigh in on all of this because I've got, I don't want to be unduly harsh to you. The court has no interest in.
Even if you evicted them today, this hour, right now, you are not being unduly harsh to them. They are the ones that are just taking this guy for a ride. This guy who is trying so hard to be nice to them, they are just like
being harsh to y'all, but at the same time, we can't be unfair to Mr. Betterton. It's just the matter of what we're here for. Mr. Betterton, what would it take?
What?
To have them out by the end of the month. What would you want in order to do that? And I realize I'm putting you on the spot and I'm asking you a question for which you weren't prepared to give an answer, and that might take, some sitting down and, ciphering and figuring, and you haven't had a chance to do any of that. So I realize my question is somewhat unfair. I'm going to ask it anyway.
So I don't want to, I'm glad to I want to show mercy, but honestly, a fair rental value would be closer to like $1,800 a month. So I guess it would take that from the time that they last paid rent until they're out at, $1,800 a month, and then plus my court costs. And honestly, I don't think they have money to pay that. And so if I could get a judgment for that, I don't know how this works, but if I could get a judgment for that, then they're going to get the overage that I paid at the foreclosure sale. They're going to eventually get that whenever the attorney decides to give it to them. So I guess I could just collect it at that time if they don't have the money to pay it now.
Well, and that's what I remind folks in your situation is that if I just lower the boom and grant the dispossessory and the figure you're asking for, you leave here with a piece of paper that says that. Or if we consent to something, you leave here with a piece of paper that says that. So people are often afraid that if they consent to something, they're weakening their position. Either way, you walk out the door with a piece of paper that says they owe you X amount of money, and they either abide by it or they don't.
I love you, Michael.
And then you have to pursue it again. It falls back on you, which sounds unfair, but
if we did agree to the end of April, it would have the power of the court behind it. In other words, if they weren't out, then I could immediately get rid of possession. Is that correct?
That is correct. And what Mr. So when was the last time what are they paid up to? Are they paid up to the middle of March?
March 15th, yes, sir.
And I don't know how they get that. They're paid up to March 15th because the last rent payment they made was in November. Hi, Mel.
So March. So it'd be 1,800 to the 15th of this month, and then half of that to the 30th. So it'd be 2,700 plus the 160 for court costs. And you said there were some other fees, late fee.
I'm not seeking
for
those.
that. Okay.
Yeah, just
so we'd be talking.
I live here with my kids, and I sent them a text message today saying, if you guys don't do this, this, and this, I'm moving out. I'm just going to move out. And then you guys can deal with everything. I think I meant it.
2860. Okay. And I'm not supposed to be, I'm not his attorney and I'm not your attorney. So but I'm stepping out a little bit because I think the court recognizes that I think you will both be better served if we can come to some consent agreement, but I am not, neither of you can both tell me to go pound sand. If you want to. What he is proposing, as my understanding, and again, interrupt me and correct me if I'm wrong, is rent at $1,800 a month
already.
past the termination of the lease, which was 15 March. So that would be $1,800 for 15 March to 15 April. $900 for the half a month past 15 April to the end of April. So that's $2,700 plus his court costs, which would be $160. So that'd be $2,860. And that's actually less than the figure that's in his affidavit.
No, it's not. Do you want to know why? In the lease that they signed 3 months ago, they promised $100 a day or $100 whatever. I think it was a day fee that they owe if they don't get out in time. They signed that lease. He added part of that to his first figure, not all of it, part of it. And when he was talking to the judge, he showed the judge exactly which page, which paragraph that this $100 fee was on in the contract that they signed. Yeah, he's not getting anything for the shredder because he didn't have to do that. He just did that. So no one asked him to do that. So he's not going to get paid for that. But the judge just conveniently forgot the $100 a day fee, and he's not gonna fight for it. He's not gonna say anything.
$2,860, and you would be out by the end of this month. Now, there are a couple of things that you need to understand. If we drew up a consent, be thinking about if those terms are palatable to you. B, everything that y'all have had up to now has been a business agreement between the two of you, and any matters between the two of you would be civil matters. If we do reduce this to a consent agreement, it's now no longer just an agreement between the two of you. It's also a court order. So it would be included in that language would be included in that agreement that if you weren't out by the end of the month, that an immediate writ would issue, and he could drive over to your place and put your stuff out on the sidewalk.
Immediate writ.
My brief association with Mr. Betterton this morning leads me to believe that's not something he's likely to do.
Oh, I'd do it.
At the same time, that would be his legal, he would be legally justified in doing that. And then as far as the 2860, if y'all want to agree to $2,860 and to be out by the end of the month, some arrangement for how that would be paid. Would it be monthly installments? Would it be a lump sum? Would it, y'all? So anyway, so that.
Donald's coming to visit me in a week, guys. We're going to go tour Lancaster. Yes, we are. It should take at least 5 minutes.
That's what I'm throwing back to you. Tell me is that realistic for you to be out by the end of the month and owe him $2,860?
Yes, sir. I did get the money on March 28th, so I do have the money to pay him now. So he doesn't have to worry about that money. I could pay that right now.
All right.
Hell no, I'm not driving.
Okay.
I'm drinking.
All right. Well, can we do it? Is it okay with you then if I prepare a document that is, it's called a consent judgment that says that's what you're agreeing to? And I'm going to ask him the same question once I get your answer.
Yes, sir.
All right, Mr. Betterton, have I said that essentially what your position is?
Yes, I believe. Yes.
All right. Well, be thinking about what I'm going to do then is I'm going to prepare the document. I'm going to since Mr. Betterton's here, I'm going to let him read it. If he sees anything in it that's a question or that he wants to redress, he'll do that. And then what I'll do, because you are remote, do you have an email address, ma'am?
Yes, sir.
What I'll do is I will email you the document and you'll do the same thing. You can read over it. And if there's something, if it says what we just said and you're okay with it, then we'd go from there. If you read it and you see something that, wait a minute, I didn't think that's what we meant by that, because that's what I want both of you to do is read it and catch anything that we've missed or misstated or anything like that. Then we would, then each of you would sign it, and then I would sign it, then the clerk would file it in, and then it would be a judgment of the court. Mr. Betterton has a question. Yes, sir.
Sorry, Your Honor, is there any way to address like personal property? Because they do have a lot of personal property, and I don't really want to be responsible for it after that date. Is there any way we can address that in the consent agreement?
And what he means by that is he keeps telling them they can leave anything they want and he will dispose of it for them. He's just saying right now, I really, really do not want to ship their stuff to them. But he said they can leave anything they want and he will dispose of it. I don't know about you, but everywhere I lived in the past, if you left anything behind, they charged you a lot cleaning fees to get rid of it.
Well, and what he's asking, and you may have heard him, and is personal property. That not only means you surrender the premises to him by that, but that term also assumes that all of your property will be gone, and again, he shouldn't be left with the expense and bother of having to remove things that are left behind. So that means everything up and gone. So I just want to make sure y'all understand that.
Okay. Thank you.
Can I interject one thing? It's not that they can leave whatever they want. I just don't want to have to be responsible for getting their stuff back to them.
Okay, I understand. All right, I misstated that. Did you hear what he just said?
So he just said he doesn't want to be responsible for sending it to.
I have to pause it for a second, guys, because something just happened. Hale, Georgia courtroom, they just went live. It is 6 a.m. there, and someone turned on the live stream. Sometimes when they do this, it's like a couple people, like the cleaning crew or the defense is getting there early or the prosecutors. It's never the judge. But they normally don't know that they turn the live on, and they talk and they say things that really, really, really should not be said on a live stream in a courtroom. All right. I don't know. I don't know if it's her, the court reporter, because that's there, or she left that there from yesterday. I don't see any bags. Who turned the live feed on? Somebody turned the live feed on. And the live feed gets turned on from the judge's desk. That's where it gets turned on from. I can't rewind it. There's no way to rewind it to go back to the beginning to see who was right there when it was turned on. That's why I can never get the very beginning of these cases in Georgia, because they don't tell you when they're going live. There's so many different links, so many. And, I just get notified after they're live, and then I have to run and I have to record. So I always miss a bit of it. But I'm so disappointed. I thought something very cool was going to happen. I thought we were going to hear a hot mic or something. But, oh well. Not today. Now this sucks because I'm not going to know if this courtroom is doing anything today, because the live stream already started. So I won't get a notification if people come in and actually start talking. So now I'm going to have to keep an eye on this all day, and I don't want to. I just want to be notified when they go live. I don't want to have to watch it. It's Thursday. You guys know what that means. Some of you know what that means. Thursday is the mental health court in Colorado. So, yeah, you mean you can set it up to record. It's not on YouTube though. But nothing might happen. Like nothing might happen all day, or something might happen. No idea. There's a lot of courtrooms though, so I wouldn't see some of those courtrooms only have cases once every 3 or 4 months. So I don't think it's worth it. I think you can go get courtrooms that are absolutely playing and record those. You get better results.
Right. So yes, I misspoke. I made it sound like he doesn't want to have to touch it, fool with it at all, bear the responsibility of getting rid of it. Now he's okay if you want to leave something behind, as long as it's not assumed that he's then going to be responsible of getting it to you.
Anything left behind is his.
Okay, all right. Okay, we good there. Okay. I'm not going to specifically put that in the order because that'll just be the way it is. If it's there, it's yours. Okay, we're going to draw up something that we hope says that. And tell when you need your glasses to find your glasses.
I've never saw a tree fall in Minecraft before. That's so cool. I'm way behind. That's so cool. Sorry, Fozzie posted a video in Discord.
Now, the agreement is going to have to say the language, defendant will surrender the property. That's a term that means not only will you be gone and anything you want will be gone, but that you've also given him the keys, and if there are any like garage door openers and anything like that. So surrender I just want you to know what that term encompasses.
Yeah, there's no way that WWE is going to get me demonetized. Oh, wait.
I apologize.
Never asked me to bring my Discord over to that screen again. Never. Wrong button. I meant to mute it.
Now, in terms of the 2860 that they say they can pay immediately, do you want that just the same way the lease says, or
I have an online rental payment that I can send them a request for.
okay?
You got chickens and eggs? You're rich. I didn't know you were a rich person. Hi, Mel. absolutely I'm going to see that movie. Absolutely. Do you want to know why? And it's not Jason. Do you want to know why? Two things are in that movie that I want to see so badly. Technoblade is in that movie. Technoblade died, but he was a great, he played Minecraft, but he was a great streamer. Oh my God, he was such a good streamer. And he died. He died of cancer. He's in the movie. Hell yeah, take my money. Name the price. I'll pay it to go see Technoblade one more time. And then the other thing is Technoblade's dad is in the movie. So since Technoblade died, his dad has been a lot of cancer, raising money for cancer and things like that. And he's been like releasing clips from Technoblade that we've never seen and things like that. It's really cool. But he has a cameo in the movie too. So either of those would have made me go see that movie. I heard the movie is not great. Who said it? Not Soda Poppin'. Who said it? Can't remember. Somebody. Some tip of my tongue. Anyway. I heard the movie was not the best, which sucks because I really wanted it to be. But oh yes, I'm going to see that movie. Yes. I'm going to introduce you all to Technoblade during the marathon. Just a small piece of him. It'll be epic. So while the judge is thinking about what to do, he's writing the order. They got to go. Does anybody know why I might have not seen Fozzie's 4 messages starting at 5:08 a.m.? Anybody have any idea why I might not have seen the messages that he put in a side channel on Discord? Oh, that's right. I'm working. It changed? I didn't touch it. Now I'm touching it.
All right, Deputy, if I can get you to, Deputy,
Yes, sir.
I can get you to hand this to Mr. Betterton, please. Okay, I've written down what I think we have said. Mr. Betterton is going to take a look at it, and he's going to let me know if he has any questions or concerns
We have said, Judge, you and me are the only people talking.
or something's missing or something like that. And then I'll scan it and email it to you. I've dated it today, so I will try and get that to you today.
I date that.
Can I ask if they don't pay the 2860, will a default judgment be?
Yes, yeah, and I'll in fact, yeah, hand me that back now.
Finally.
That way you don't have to, file anything again, so.
I think they'll pay. I just covering my bases.
Well, it does. It should be in there. You're exactly right.
okay, I'm sorry.
Thanks. I don't know why I keep handing you that second blank page, but anyway, it's just. All right, thank you. Mr. Betterton has signed it, so I will email it to y'all. And if y'all, if you agree to it, then we will, I'll consult with my boss and see what will be acceptable in terms of you being able to, arrange for it to be signed or to be signed for you. And then you will get a copy, and then the matter will be closed. So I've got a couple other matters to hear today and on this morning's calendar, and then I will go back and get this to you.
Okay, thank you so much.
All right, thank you. Mr. Betterton, anything else you want? All right, same thing. Normally we would, have all this signed, stamped, filed, and you'd walk out of here with this in your hand. Since we can't do that until we make whatever arrangements for them to be able to sign it, do you want to? I didn't even look to see where you are.
I'm not too far.
If what we can do is, do we have a good phone number for you?
What?
Give me a good phone number for you.
770-826-9338.
9338. All right. We will call you as soon as we know something, and either we can have your copy waiting for you in our office, or we can put it in the mail to you, or whatever you decide at that moment.
Thank you very much for your time.
All right.
Appreciate
Thank you. All right, Mr. Ms. Boucher, that concludes the matter for the moment. We're technically, until you sign this, we're technically in recess and not, so we will, we'll get this to you, let you look at it. If you have any
Prove it. I need evidence.
concerns, we'll contact Mr. Betterton and let him know what since he's already signed it, I have to, let him know if we do change anything on it and go from there. But I'll try and get this to you today so that the date that I have on it is the proper date. All right. And give me your email address.
When you heard the first playing when it's outside getting yelled at. The second playing when it's outside to see what's going on. And then yelled at him to stop putting things in the pothole.
The echo goes away in just a moment. So everybody just relax. I don't want to hear one thing about the audio. It's fine.
The second playing when it's told the defendant he was fixing the hole. And then both the playing witnesses pointing at them with their fingers, making a pistol shape with their fingers, saying, "I'm going to shoot you."
Wait, you said there were two complaining witnesses?
Yes, Your Honor.
Okay.
That's what I have here. It says, "I'm going to shoot you," towards both complaining witnesses.
And we have Ms. Agbacieli making the alleged threats?
Correct, Your Honor.
Your Honor, there's only charges one.
There's only,
Right.
Yes, Your Honor.
Okay, who is the complaining witness?
Video strong.
Is it a known person? Because we have priors with Ms. Agbacieli, and there are assaultive and, pretty dangerous priors. Any of the same complaining witnesses?
Does not appear so, Your Honor. I'm looking through. No, Your Honor. It seems like it's just, from what we can see, it's
Was it a street worker? Was it someone working for the city, or
It's someone that lives there, Your Honor.
just out there fixing the potholes?
That's correct, Your Honor.
Okay. All right, Ms. Agbacieli, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand, ma'am?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer, ma'am?
Yes, Your Honor.
Okay, we can give you time. So what I'll have you do now is I'll have you sign a receipt of Victoria, we'll have you take a seat while we draft the bond conditions, we'll have you sign it, and after that, you'll be free to go.
Yes, Your Honor.
Please, ma'am, don't pick up any new cases. Just don't have contact with these people. I don't want to have to put you in jail, you know?
Your Honor, it was the same thing the last time, the
Just,
last case.
just please be careful, you know?
Yeah.
Really.
People make false allegations all the time.
And I get it. There's always two sides to the story. That's why you have a lawyer. That's why we'll give you time. But the evidence will point to whose side is correct.
Yeah, and I
you
do
know,
have them.
So please.
Thank you.
Yes, ma'am.
Judge, there's an echo.
All right, Judge, next is page 13.
Is that better?
Ramona.
Much better.
Is that better, Ramona?
Yes, much better.
Yeah, okay. It's the same thing. I gotta have to mute.
That is just the no contact, the
No
no.
contact with complaining witness, don't go where he lives, and no weapons, please. I missed who's this?
Page 13, Kyle.
All right, good morning, Mr. Kyles. Sir, you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 2nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched from an apartment complex and spoke to complaining witness who said that she was laying in her bed and was awoken by her son, the defendant, screaming.
Yeah, but can he
And
bite my
initially, there were
ass?
2 gunshots go off in the apartment. Complaining witness then got out of bed and took the gun from the defendant, hid it, and called 911. Upon arrival, the law enforcement officer recovered the weapon, along with 2 fired shell casings and 2 fired slugs matching the caliber of the pistol fire. Upon contact with the defendant, the law enforcement officer noticed the odor of alcoholic beverage and that the defendant was wet while fully clothed. The defendant stated he had
So, whoa. Defendant was what?
wet while fully clothed.
Wet while fully clothed. Okay.
Sure. The defendant stated he had been drinking alcohol and smoking marijuana and that he fired the firearm in the apartment. The defendant stated he was wet because he dumped a bucket of water on himself. The defendant stated that he was paranoid at the time.
Mr. Kyles, I'm sending you for a drug test. I want to know what, if anything, was in your system. You're to come right back. I will appoint you a lawyer today, but you're not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. You're also not to be in possession of weapons. Do you understand?
Yes, sir.
So do you guys have a rip done on this case? Do we know whether she wants him back at home or no?
I made contact with the claimant's owner, however, she did not wish to talk with me about the incident after.
She want to talk to you?
No, Your Honor.
Okay. Don't be in possession of weapons, Mr. Kyles. You know, I don't want to have to put you in jail and make your bond high. I don't know if you have anyone in this life that is prepared to pony up $5,000 to $10,000. So when you're out there in the free world, if you don't have anyone that's going to, you know, pony up that money for a bond, you'll be stuck like Chuck in there. So be careful. All I want is my city safe. You understand?
Yes, sir.
Okay, so what we'll do is I'll appoint you a lawyer today. Or do you have the ability to hire a lawyer, or would you like a court-appointed lawyer?
You can appoint me a lawyer, and I may consider hiring one if the understanding is not
I
understood.
just want to know whether you want a court-appointed lawyer or not.
Yes,
I
sir.
can
Yes,
appoint
sir.
you a lawyer today. I'm sending you for a drug test. I want to know what, if anything's in your system, come back, and then I'll have a lawyer waiting for you.
Okay.
Okay, please.
That's my seat right there. That's,
No,
that's
I
my
haven't.
seat.
All right, go ahead and sign.
Fozzie, I drank that beer Terry gave to you. I drank it.
You speak English, sir?
Yes, a little bit.
Do you want a translator?
Yeah, that's better.
Okay. Tome asiento, por favor.
I shall translate.
Next
Oh,
judge
darn.
is page
Darn.
21. Horan, come on up. The thing is not to do, and I'm just going to religious and civic aspect field, it's in trust services. I have a support and the chapter with one local perspective. When you're done, you can come back.
Biting is bad. Kindergarten 101.
Yes.
I only love punch, your judge.
I'd like to know if he has any open cases right now, please.
Yes, Your Honor.
Mr. Torres, you're charged with driving while intoxicated. Probable cause as found in your case. Your case is 332 days old. I'm now going to put a monitor on your ankle so I know where you are at all times. You're not to consume alcohol or illegal drugs. If I find that you're using, I'm going to keep you. Do you understand? You've already taken off from me multiple times. The next time you take off from me, your bond is going to hit the clouds. Do you understand? Don't say anything. I want you to understand that it's been multiple times. Do you understand?
What do you mean by multiple times?
You have not come to this court multiple times when you were required to be here.
What?
I'm not sitting around.
They have Spanish in school, but they teach you words like biblioteca, which means library. It's very useful Spanish they try to teach you.
It's just that's the fact. So, does he have anything open?
No, Your Honor, it does not.
Okay, I'm going to appoint you lawyer today, and we're going to figure out what happens with your case. Take a seat for me in the jury box, please.
This way.
I don't know if I'm going to reset this case. You can have him sign, but I don't know if I'm going to reset this thing. So,
Me llamo as Kathy.
Next is page 23. Shaw.
I took a lot of Latin in school, starting first grade.
good morning, Mr. Upshaw. So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
I know where that
You have the right
is.
to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 5th, 2025, a law enforcement officer conducted a traffic stop due to a heavily tinted
I'm pausing it for this next one, guys. Dos Equis.
motor vehicle in Harris County, Texas, and also for the defense failure signal within 100 feet before making its turn. The officer told the defendant to lower his windows for safety. The defendant slightly lowered the rear window, the officer was still unable to see inside the vehicle. The officer asked the defendant again to lower the window. The defendant said he did not have to. The officer observed the defendant acting nervously by breathing heavily and staring at the floorboard of the motor vehicle. The officer told the defendant to step out of the vehicle for safety. The defendant refused. The officer opened the driver's door and told the defendant to step out of the vehicle. The defendant declined again. The officer grabbed the defendant's wrist and attempted to pull the defendant out of the vehicle. The defendant resisted by clenching his fist and pulling his arm away towards his body. And the officer told the defendant to step out again, to which the defendant stated he did not have to. The officer attempted to pull the defendant out of the motor vehicle. The defendant continued to resist by pulling his arm towards the body. The officer was able to pull the defendant outside of the car. The defendant again resisted by clenching both fists and refused to place his hands behind his back by tensing his arms and pulling away. The officer and his partner forced handcuffs onto the defendant in order to perform the arrest.
Mr. Upshaw, I'm going to find that there's sufficient probable cause to
Not
go forward with your
cigarettes,
case.
but knuckles.
Can you run
Yes.
his license? I see there's a valid one. The only bond condition I'm placing on you now, sir, is that you're not allowed to drive unless you have a valid license, a Texas driver's license, and liability insurance in your name. I'm just asking you to follow the law. If you do not have one or the other, then you're not allowed to drive. Do you understand?
Yes, sir.
His license is eligible.
Okay, so I'm gonna have you sign conditions to that, and then
That's
you
what
have
I
the
call my
ability to hire a
son.
lawyer.
Yes, sir.
I say a
Okay,
few more
we're gonna
words
give you
too
time
that
to
I
hire a
can't
lawyer,
repeat.
so I'll have you go to
But
Victoria, sign a
Gorgo's
receipt.
one of
We'll have you take a seat in the jury box. I'm gonna get you bond conditions. We'll have you sign it, and that's it. You're free to go. All right? Please.
Judge Fellows, THA.
Yes, ma'am.
All right, Judge, next is page 24, Weaver, come on up.
Is this for Blossom?
Oh, so sorry, I totally forgot about the no, the one for Plaza is on page 20. Plaza.
I guess we'll do this now. All right, Mr. Weaver, you're charged with theft.
Since we're talking about speaking Spanish real quick, I have to tell you guys the other day, I asked you guys if you knew Mark Anthony or if you spoke Spanish to say so in the comments so I would know. Because on Sunday, we have open mic at my bar on Sunday. And on Sunday, oh my gosh, this girl comes in with the greatest voice ever. It's beautiful. It gives me chills. It makes me cry. It's beautiful. Her voice is beautiful, right? So, like, she came in. She doesn't speak a lick of English. She only sings Spanish songs. So I'm like, Ziomas, that's her name. Ziomas. I said, me and you. I said, we're going to sing together on Sunday. Me and you. Mark Anthony. Contra la Corriente. That's what we're going to sing. Let's go. I'm pretty sure she understood me. Because I said broken Spanish. Yo y mi cantas. Sábado. Right? This song is so hard. I didn't remember that it was that hard when I said that because I'm an idiot. So I was practicing and I was ready. I was ready on Sunday to go up and sing this insanely hard Spanish song with Ziomas. I was just going to keep the mic like way down so no one could really hear me, right? I was so nervous. I was so scared. I practiced and practiced and practiced and practiced this song. She never showed up. She ghosted me. So I didn't get to sing with her. Oh, God, her voice is so good, though. Hi, Nancy.
You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On November 15th, 2024, in Harris County, Texas, an officer was dispatched to an Academy store. The officer made contact with the complaining witness, a store manager that observed the defendant remove a pair of shoes from a box, place shoes on his feet, and proceed past all points of sale without paying for the shoes. The shoes are valued at $129.99. The defendant was observed arriving and exiting the property in Ford Expedition, and be associated with an individual who was identified as the defendant. The officer was able to positively identify the defendant as the defendant with his driver's license photo compared to the surveillance of the theft that occurred on November 15th.
What was the value again?
The value was $129.99.
All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go back to any academy. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. How did Shreya already get this? This is Weaver, right?
I believe he was in another county.
Oh, that's why okay. So what we'll do now is I'm going to have you sign a reset and then I'm going to have you take a seat in the jury box while I get your bond conditions. I'm going to try to find your lawyer too so we can get you all on one page. And then after all that, we'll get you out of here, okay? Do not leave until we excuse you, though. Please. Can you file no going to any Walmart, please? Or I'm sorry, Academy.
Yes, sir.
All right, there's next is page 20. You thought?
Do you need the copy?
Yes, Your Honor, I have it. Buenos días, escucha el caso.
Good morning, Mr. Teapot.
Buenos días, señor. Teapot.
You are charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine.
What is the multa?
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On August 1st, 2019, Surveillance video recorded a gray Chevrolet Avalanche bearing a tipper license plate, and also recorded two Hispanic males exit the vehicle and illegally dump a refrigerator on the side of a street easement in Harris County, Texas. The weight of the waste was approximately 117 pounds. The officer used the license plate to identify the defendant. The officer compared the surveillance video to the defendant's driver's license photo and believes the suspect to be the same person.
Right down the road,
See the person?
35, 40 minutes.
There's surveillance of him actually dumping the fridge.
Yes, sir.
All right, Mr. Bucks, I'm going to find that there's sufficient probable cause to go forward with your case. You run his license, please.
Yes, sir. Your Honor, I just have one moment.
Sure. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. And that is a condition of your bond. If I find that you do in violation of this, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it daily, they will put a detainer on you and you will be stuck in there until this case is over with. And then you get shipped off to immigration. Do you understand?
Yes, sir.
So just be one moment, Your Honor. It is eligible, Your Honor.
Okay. So we will create bond conditions to this effect. I'm going to have you sign a reset, Victoria. I'm sorry, do you have the ability to hire a lawyer?
No, I don't.
I need to see if you qualify for an appointed lawyer. So what we can do is we can have you fill out an application. I need to know everything about you, whether you work, what kind of work, your monthly income, money you have in the bank, what kind of car you drive, and then I'll take a look to see whether you qualify. Debbie will give you an application. I'll have you sign a reset, or I can take a sit in the jury box while we get your bond conditions. And then after that, I'll take a look at the application.
All right, Judge, next is page 24.
Oh, if she would have said page 13, I would have kept going. But we made it to the end, guys. Thank you so much for coming out. I really, really, really appreciate it. Today's Thursday. Mental health court day. Oh, I can't wait. All right, guys. I will see you all soon or tomorrow or later today. I don't know when I'll see you. But behave, okay? Have a great day, guys. Bye. Thank you so much.
Electric light, late night when the world sleeps. there's no